then this would have to go out to a vote of the members to make that change. And we'd need more than a simple majority to confirm the vote.
Okay. Okay, it is now time for the chair's remarks, and I'd like to start off today with a quotation that appeared in this week's Time magazine. It was made by Scott Walker, the Republican governor of Wisconsin, who became the first U.S. governor to survive a recall. We tell Wisconsin, we tell our country, voters really do want leaders who stand up and make the tough decisions. In today's fast-paced world and current economic condition, leadership of our country, our state, our county, our city, and even in United Laguna Hills Mutual, your board of directors must make the tough decisions. Decisions made by your board are not always popular with everyone, but they are made according to the laws that govern a California corporation. There are those in our community that stand at the microphone at a board or committee meeting, or before a group at a club meeting, write articles to the Globe, or distribute what they want by email within the community or through the internet to outside interests, both local and national, to promote their doctrine. Members of various groups will promise almost anything to get their candidates elected. But once these so-called reformers sit down in the 11 chairs of the board of directors, reality, no actuality, as they say on television, comes into play. And who would they blame when things happen a different way later? Constantly we hear the so-called leaders of groups say, we want transparency from the board. We want true facts on the issues. We want. And when it is provided by your board of directors, such as the chair presented to you last month at the board meeting, showing documented proof and holding it up for you to see, they cry foul. They send abusing, trash emails, all because the truth did not fit their agenda. One email called me a pathological liar, even for showing you those items that I held up. Another one says, why do they call you a condescending son of a bitch? This email came from PPV to its people, chastising them because for 2 weeks there was no articles in the Globe against the 6-month rule. They send out 13-page protect property values in Laguna Woods to the internet, which is now all across the country. Would you want to move in when you open up to look at Laguna Woods Village and you find this? They sent out another email, and this one we are going to respond to you today as a board. The Protect Property Values Club, or PPV, once again, as I said, sent out emails on decisions made by your board to protect its property and do its fiduciary responsibility as required by law, with direct lies, half-truths, and misinterpretation, all to inflame the united community against your current board and garner support for their organization. Now, I have been authorized today by the board to read to you, the united community, their email, and to provide the truth to you, our membership. In their email, PPV stated, first item, dear neighbors, in their relentless campaign to send our property values plummeting even lower, the United Mutual Board has just passed yet another irresponsible resolution. In another closed session where the board handles controversial matters and where members are not permitted, new criteria was imposed for buyers wishing to qualify to buy a co-op. What we share with you is not rumor. The new requirements listed below have been confirmed by Jerry Storage, the general manager of PCM. The truth, ladies and gentlemen, the resolution has not been passed by the United Board and will be on, and as it is today, on today's agenda. The resolution was discussed in open session, where members are encouraged to participate at the April and June finance meetings, and at the April 10th and May 8th board meetings in this room. It was agenda item 9 on both board sessions. The general manager, Jerry Storage, did not participate in the discussion and does not need to confirm resolutions that are publicly discussed. Jerry has confirmed to the United Legal Counsel that he did not make the statements attributed to him by PPV, and he will comment on that later. PPV states, 1, our board has decided without input from the mortgage or real estate industry that United will no longer accept equity in residents located in the United States as an asset for qualifications to buy in Laguna Woods Village. So those few potential buyers who are fortunate enough to have a home equity in this historically lean housing market are automatically disqualified. The truth, ladies and gentlemen. Frank Hill, broker for Century 21 Rainbow Realty, and Dwight Moody from Premier Capital Mortgage attended the April 30th Finance Committee meeting and discussed their concerns. United will, let me repeat that, United will accept equity in a residence as long as it meets the criteria for acceptable asset. The asset must be liquid, marketable, or income producing. Listing a residence without other assets and without showing that it is for sale or income producing does not meet the liquidity requirement. The purpose of financial requirements is to show current and future liquidity that is sufficient to pay assessments. This has been in here since day one when this place opened. PPV states, no longer will our board accept assets held outside U.S. borders. That means foreign nationals, Canadians, Australians, Koreans, Japanese, Brits, etc., with the means and the interest in living here are no longer welcome. The new law mandates that they will no longer qualify to buy a co-op unless they move their money to U.S. soil. Money held in U.S. banks on foreign soil no longer qualifies. This new law is not only discriminatory, but it is a terrible idea as it reduces even further the pool of qualified co-op buyers. Ladies and gentlemen, now the truth. Collecting delinquent assessments when assets are held outside the U.S. is difficult, if not impossible, in some situations. The United Board looks at ways to minimize the risk of not being able to collect delinquent assessments. And remember, when delinquent assessments come in, we still have to pay GRF, and that money comes from you. The second part of United's response on this is the revised administrative guidelines for financial qualifications say examples of acceptable assets include funds in U.S. financial institutions, funds held in U.S. banks on foreign soil are acceptable. PPV states on their email, our United Board has now instructed PCM not to do pre-approvals for prospective buyers. Linda Woods, membership coordinator for PCM, normally processes approvals and passes them to the board for ratification. But now she is no longer allowed to speak with buyers to explain the qualification and answer questions. Why would our overboard bird take on the time-consuming task when we have paid employees who has the expertise to perform this task and has done so for years? The truth now, ladies and gentlemen, PCM does not do any approvals for prospective buyers, pre or otherwise. Let me repeat that. PCM does not do any approvals for prospective buyers, pre or otherwise. There is nothing in the administrative guidelines that speak to pre-approvals under any circumstances. The guidelines state the prospective buyer of a unit shall submit satisfactory verification of assets equal to the purchase price of the unit plus $125,000. How can directors pre-approve applicants when purchasing information is not provided? The board is charged with the responsibility to manage and protect United. Verification of assets for potential purchasers is included in that responsibility. Linda Wood's primary responsibility is to process membership applications, and another staff member processes occupancy applications submitted outside the resale process. Prospective buyers' inquiries are routed to the community service manager. Directors have the responsibility of reviewing applications, verifying that the applicants meet the qualifications, and approving or denying the membership application. Directors must comply with the Fair Housing Act and California Civil Code 51.3 for senior housing developments. PPV states, what are the implications for our future? You and your heirs are trying to sell your co-op. The buyer wants to use the equity in their home as part of their asset qualification. The board says they can't for most buyers. A home is their single and largest asset. So your co-op takes even longer to sell and most likely at a lower price, further depreciating your estate. Here is the truth. United will accept equity in a residence as long as it meets the criteria for an acceptable asset. That asset, as stated, must be liquid, marketable, or income producing. Listing a residence that is not for sale or income producing and not listing other assets does not meet this criteria. PPV states, since PCM can no longer do pre-approvals, does that mean the applications will go directly to the board, who will then be able to cherry-pick buyers? Who ensures the integrity of the application process? Who verifies information? The truth. PCM reviews all applications before sending them to the board to determine if the information and documents meet the requirements. If staff has any questions regarding the application, they may contact someone to verify information. The board has no reason to cherry-pick buyers. Their main concern is, does the applicant meet the age and financial qualifications? Directors must comply with the Federal Fair Housing Act and California Civil Code 51.3 of the senior housing laws. PPV statement. Since the burdensome practice is regulated to co-ops only, doesn't this make a condo and Third Mutual an even more attractive sale? United is a stock cooperative. Transfer of membership in United is not a transfer of title to real property. It is a transfer of membership with an exclusive right to occupy a specific unit within the development. Membership in United is a tenant-landlord relationship. Some co-ops go as far as to interview applicants to determine their suitability. United does not engage in this process. United resales have also consistently been greater than resales in Third. PPV states, these new rules are so blatantly discriminatory that a cluster of lawsuits against United will surely follow. Is that how we want to spend our reserve funds? And when our reserves dwindle, will there most surely be another hike in our HOA fees? The truth. United financial qualifications are fair and reasonable under the laws and will likely prevail in any lawsuit. PPV states, please consider the following. Have you ever seen these restrictions on co-ops up for discussion on the agenda? Yes, we have. In fact, the guidelines were listed on the agenda as items 9B on both the April 10th and May 8th board meetings, and I've said earlier, also in the committee meetings. PPV states further, did you know that only a few weeks ago, our United board in another closed session hike the processing fee for leasing, whether 2 months or 6 months, from $110 to $300. The truth. The increase in processing sublease permit was discussed in open session at the April and May board meetings and was recommended by staff to cover administrative costs associated with processing the applications and providing security checks as needed. PPV states, without considering home equity, our board has made the buying of co-ops available only to buyers with all cash. The truth, ladies and gentlemen. United will permit the buyer who does not meet the financial requirements to have a guarantor. The guarantor shall provide satisfactory verification of annual income of at least $90,000 and marketable home producing assets of at least $250,000 plus the unit purchase price. The United board must protect United's assets, which includes confirming that prospective purchasers will be able to meet their financial obligations to United. The board may consider waiving financial requirements. The board may consider waiving financial requirements to a prudently, the board may, of course, may consider waiving the financial requirements if the applicant obtains financing. Applicant obtains financing from a financial institution of at least 50% and not more than 90% of the purchase price. PPV states, did you elect our board to create prejudicial and discriminatory practices on your behalf? The truth. The board has a fundamental responsibility to prudently represent the members of United in directing the business and affairs of the corporation within the laws. PPV states, did you want your co-op property values affecting you, co-op owners or heirs, to plummet? The truth, ladies and gentlemen, property values have been declining due to the housing market and are not the result of any changes in United's financial qualifications. And we have demonstrated that to you last month by showing you some articles out of the paper and reading you some documents. PPV further states, what motivates the majority of directors on our board to pass such harmful, detrimental, and ill-advised measures? Are they hopefully ignorant of real estate matters, or do they have a hidden agenda? The truth. Directors must make decisions based on what they believe is in the best interest of the corporation, which is composed of 6,323 shareholders. United Co-op sales have been consistently greater than sales of condos. PPV further states, what is it and why is our board abrogating its fiduciary responsibility to protect our property values? The truth, United board is working diligently to protect the assets of the corporation. PPV, and finally, why do you think that these issues are not openly discussed? The truth, ladies and gentlemen, these issues were discussed openly, but obviously some members of the community are not inclined to attend committee or board meetings or even watch the board meetings on Channel 6 to see them being discussed at the committee and board meetings. They further go on, what can you do? And they ask you to send this out to your friends. They also ask you to support PPV's goals of replacing 4 of the board members who are running to retain their seats and to make a contribution to their organization. I want you to know that the 4 members running for this board, whose time has come up on the board, not one has put in yet to rerun. Another mistake. They've also asked you to make donations. I have articles that they put into the Globe asking you to make donations. I would like to talk about something else now, ladies and gentlemen, the so-called secret meetings. We've heard this for years. You've heard it today, you hear it every day, you see it in the paper. Once again, this is the Monday memo. It is in every single clubhouse and it is on the internet. It tells you of every board meeting, the location, time, and date for all the mutuals for a 2-week period. It is also in the Globe every week under board committee meetings. There it is, ladies and gentlemen, all the meetings. So where's the secret? You can come up to the second floor and you can get this list. Board and committee meetings of every single mutual, every committee meeting, the time, the day, and we're going to meet, what room, for a whole year. You can set your calendar for a whole year. You want this? It's available to you. And I want to read a statement, ladies and gentlemen, because people talk about Davis Sterling, so I'm going to read you what it says what an executive session is, so that you understand once and for all. The executive session board meetings. The board is permitted to hold an executive session only to consider litigation, contracts with non-owners, owner discipline, in which case the subject owner may attend, personnel matters, and to meet with an owner at the owner's request to discuss delinquent assessments. If the entire meeting will be executive session, owners may not attend but are entitled to notice of the time and place of the meeting by at least 2 days. Executive sessions or closed sessions are held by every single corporation in the United States, public or private. It is held by every governmental agency, federal, state, county, or city. Even you hold private sessions in your club, be it PPV, be it the Comedy Club, the Nifties, Friends of the Village, any club. Boards meet to talk about issues. They don't stand up in front of the Comedy Club and say, ladies and gentlemen, we're going to hire this person, they want $500. All in favor of voting for that. So you have meetings. These are required. I want you to keep a figure in mind, ladies and gentlemen, and that is $253 per manor, or $21 a month. I'm going to talk about that a little later. If you want to know information on your manor, your maintenance, nothing is secret. Here it is. Go in, across the hall, you fill this out, they'll give you your maintenance records. You want to lease your co-op? There it is, ladies and gentlemen, all the rules. Walk across the hall, it's available to you, no cost. You want to know how to sell your place, or you want to go to a realtor and you want to know what the rules are? There it is. You could do it all yourself. There it is, no cost to you, right across the hall. They complained about the stuff I held up last month, and I didn't give the dates. This is May 17th of this year. Home sales are up 17% for the year. May 17th this year. Home new buyers see low payments. In fact, the payment you're paying today is half of what you would have paid in 2006. They talked about condos being better than co-ops. In April 8th, the Buzz 6 areas are hot spot for sales. But right here, ladies and gentlemen, the 5 hardest to sell markets in Orange County list Laguna Woods condos in that 5 as the hardest, not the co-ops. Okay, excuse me. Ladies and gentlemen, it's still the chair's remarks. Okay. Recently, I attended a meeting of another organization here that's been very vocal. And they talked about the management agreement, and we have to get rid of the management company and all the secret meetings that the boards are having, on these secret agendas and the secret negotiations. Ladies and gentlemen, this is the management agreement. If you personally want a copy, go up to the second floor. There's a form by the state of California. Sign your name to it, you get a copy. In the past, the boards have all signed 5-year agreements with the management company. We have a 1-year agreement with a 30-day cancellation clause. That agreement was written by our corporate attorney. It was not written by other attorneys for all the boards. We have put PCM on notice that they have to respond. And that brings up another issue that was brought up at this meeting, that when you stand here at this lectern and you talk to us about your problems, we are not interested as a board. PCM is not interested. Jerry has a computer here, ladies and gentlemen. When you come up and you give your unit number and you say, I have a problem, he has your unit up here and all the history of it. If you say you have a problem with your plumbing, he knows what happened, and he's also giving that message to all of his managers at the same time to verify everything. So we know what is going on. We don't always answer you because we have an agenda and some items cannot be put on. There was another comment made, and unfortunately I must address that at this time. And although it didn't normally concern United, but it's now because of our election, the innuendos are coming out. The comments were made at this meeting that the election in 3rd was bought by board members receiving, some say, $20,000 from outside sources. It was also asked, who is paying for votes of board members? This is the PPV in the Globe ad asking you for money to help support their 4 candidates running for the board, and we already read an email with that same information with their name on it. And this is from Stephanie McGid, or Stevie as she is called. These comments by the leadership of the other group, which I won't mention, are very interesting, since they are personally supporting PVV with organizational help and are supporting their candidates in the past. And although they say they will not make an actual announcement of who they're supporting, they say call the leader and they'll tell you, and we know exactly who they will do. There was another comment made, ladies and gentlemen, that good people were not elected to 3rd board because the Asian community voted as a bloc. That is a derogatory comment, and I would like to say something to our Asian community, and I hope I say it correct. To the Koreans in this community who wish to move into this community, Oso, Oseo. To the Chinese community, Kwan Ing, Neiman Lai. To the Japanese community, United E, Yokoso, Minasan o Kangyo. And for those who don't speak Korean, Chinese, or Japanese, I have said, you are welcome in United. Okay. This board, one moment, this board will not discriminate against anyone wishing to live here based on their sex, their race, their religion, their country of origin, their marriage status, their sexual status. We only look at the age requirement, which is federal law, and the financial requirements. We represent the community, and we're sorry that a vocal group, or multiple vocal groups, have taken the time away from our telling you all the good things, and next month I guarantee you we will concentrate on telling you all the good things and giving you the mid-year report that we normally would have done today. And now we will go on to the next item. And one moment while I clear away.
Mr. President, I move that we approve the minutes for both May 8th and May 14th, the regular and special meeting.
Okay. Is there a second? Okay. Any discussion for the board? Okay. All those in favor? Let's approve the minutes, Barbara. In favor? Okay, it's unanimous.